although my time's going to be brief. Randall Harris, I'm Director of Church Relations at Freed-Hardeman University, and I do many things there in that regard, but one of those includes something we're doing here today. We at Freed-Hardeman, we look at congregations who do many things for the university, send a lot of students there, financially support the Bible teaching program, et cetera, lots of different things it could be. But churches who are of great value to us, that we work really well together and do things to help each other, and this happens to be one of those congregations. Great Oaks is a wonderful congregation and a great blessing to Freed-Hardeman University, and this is a way that we can try to share a blessing back in this regard. This is an area that incorporates into everyone's life at some point in time. It comes to us all, and there's just a lot of things there. I know I've looked at my own estate planning prior, and I thought I was pretty sharp along those lines, and started talking to Jeremy, and I found out all kinds of things that I misunderstood or just totally didn't understand at all. And because laws and everything change from year to year to year, you can be Solomon 1 year and 2 years later, not so much. So this is a great opportunity for us to get back to you and provide a service such as this. And Jerry will share these things, and he'll be going through with you on what we have here today. Just to mention, we've got a great book that one of our attorneys for Freed-Hardeman University, literally hot off the press a couple of months ago, wrote a book about giving and how it relates to the Christian. And these are free copies for you, and we have one for everyone here. So be sure and take one of those with you. It's a great short read, but very important. And Jeremy will be referring to some other documents that we have up here that we would like you to take with you as well. And I'll just go ahead and we'll get right started and turn it over to him.
All right, thank you. And I appreciate everybody coming this afternoon. I know it's a little bit tough when you walk in to a conversation about death and taxes in the middle of a Sunday afternoon. But we're going to try and make this as interesting as we possibly can. Just so you know, those, if you didn't know, those two letters after my name basically mean I'm an attorney. And if you didn't know I was an attorney before you came in, please don't run screaming out of the room now. That does happen every once in a while when people figure that out. But we are going to be talking about estate planning today. And so let me go ahead and get some kind of basic housekeeping stuff out of the way before we jump into the topic. It's important, I think, to understand what my relationship is with Freed-Hardeman and what my relationship is with you guys if you choose to continue working with me in any way after the meeting today. I'm work with a company called Thompson & Associates. It's a company that's been around for a couple of decades. We work with charities and nonprofits across the country, doing exactly the same thing we're doing at Freed-Hardeman University with each one of those organizations. But they hold our company on retainer to be able to offer consulting and educational services like this to whomever they want to offer that service to. And at the end of this seminar today, or that's always kind of a fun word, presentation, joyful event, maybe we'll call it that, for at least the first 5 minutes, you'll have the opportunity, if you want, to have a more private discussion about your own planning. But as you'll learn, and I'll emphasize and remind you at the end, I'm not here to act as your attorney. I'm not here to take business away from local attorneys or advisors. I'm an educator and a consultant. My role is to give you the information you need so that when you walk into your attorney's office here locally, you'll be an informed consumer in that process, as opposed to the kind of the traditional client that walks into my office in Nashville like a deer in the headlights and you know, trying to get in and out as quickly as possible. So we'll talk a little bit more about what that might look like and what all these papers are up here mean if you choose to take advantage of that as well. That's another great service that Freed-Hardeman is able to offer through Great Oaks here. So I think that's something important to understand. But we are going to be talking about the incredibly exciting topic of estate planning today, right? I made a joke about death and taxes. That's kind of what we're going to focus on a little bit this afternoon. This idea of estate planning, I think, is an important one. It's important enough that, there's a lot of talk about money in the Bible itself. There's one parable in particular that I like to refer to, the parable of the talents. It's a parable we're probably all familiar with in this room. to some extent, but that's a parable that is, in its most literal sense, an estate planning parable, right? Now, because of the way that the actual biblical language is translated into English, we often do Bible lessons, at least when I was growing up, in the church I grew up in, as a child, about things very different than money or estate planning with that particular parable, right? In part because the translation of the word that's used there is talents, and we have a completely different meaning for the word talents in our English language, and so maybe this was true of you. A lot of the Bible lessons I got growing up about the parable of the talents were centered around using my earthly talents, right? Whatever the gifts were God gave to me, and we talk about things like my ability to sing, which is not a talent, or my ability to preach, which some would tell you is also not a talent, or my ability to, help the church out in some way, or help the Lord's work out in some way. Those are the talents I should be using to give back to God with. But in its most literal sense, the parable of the talents is an estate planning story. A master gives his servants certain amounts of money, and then he leaves them for a period of time. And when the master returns, he expects his servants to not only give him his money back, but to have made a return on his investment and give that money back to him as well. Right? And the servant that is chastised and cast out isn't a servant who abused or misused the talent that was given to him by God. It was the servant who just did nothing with it, who didn't prosper with it, who couldn't return on the Lord's investment. Right? And so I think that's an important context for what we're talking about here. This is a conversation to some extent when we're talking about estate planning, about stewardship, because we're all given certain resources by God, and we're asked to do things with those resources that will glorify Him, and He's going to seek a return on that investment in each and every one of us. And so I think it's important to, one, understand what's involved, right? To educate yourselves, and that's what we're hopefully going to do this afternoon. Give you some ammunition, for lack of a better word, that will help you as you seek to do what's best with the resources you've been blessed with and accumulated and worked hard for over the course of your lifetime. And what is best for you and for your family and for your situation and for what you want to accomplish with everything that you've accumulated over your lifetime is different. The motivations behind those obligations or desires are different for each and every one of us, right? The things that we need to accomplish are different. And what motivates us to really do estate planning is different. And so I'm going to start by explaining why estate planning is important to me, because I think it'll help set some context for this. And I'm also following the advice of a colleague of mine from probably a decade or so ago. As I was getting ready for a similar presentation, I was flipping through some slides on my iPad, and my colleague was next to me as we were trying to figure out what to talk about, and I accidentally came across a picture of my kids, and she stopped me right then and said, "Now, Jeremy, from now on you should start every presentation you make with a picture of your kids, because they're a whole lot cuter than you are," which is true. And so there's my kids, right? And I'm giving away boys if you would like one. This picture is a little bit old when they were still cute. My oldest is now 16 and can drive and is apparently the smartest person on planet Earth. So if you want a boy, that's great. My little girl is perfect in every way, and she will be staying with me for as long as I'm alive. But these are my 4 kids. And I show you this picture for a couple of different reasons. One, because I see some smiles on your faces. That wasn't the case for some reason when the attorney started speaking at the beginning of this presentation. And so that's one reason why I show you this picture. The other reason is because this is why estate planning is important to me. Right? If something were to happen to me, the primary motivation behind everything that's in my will, in my trust, in my entire estate plan is really centered around, first and foremost, making sure that these 4 faces are taken care of. That the things that I hope to be able to provide for them by simply living and providing for them will continue to be provided for them even if I'm not here. And so there's language about a trust for my kids, because if I just left them a big sum of money right now, right, they live in a house full of Legos that you couldn't walk through without cutting your feet up, and have a cabinet full of Pop-Tarts to eat from at every meal, right? And that wouldn't last very long. And so there's some trust language in there, because I don't want to leave it to them right now. Certainly, I may never want to leave it to them completely, with the right person that I trust in charge of that money until they become old enough and hopefully at some point mature enough to handle that money on their own, with some instruction as to what that money should be used for, what's important to me, right? All of that's in there. The person that I would want to raise them if I'm not there to raise them myself. That's named in my estate plan, right? Somebody with similar values, similar ideas, similar parenting style, similar geography now that my kids are a little bit older. Because the last thing I would want if they lost their father is for them to also lose all of their friends, to get picked up and moved out of state to a guardian that lives somewhere else. And so things that maybe weren't important as I was just thinking about these things 5-10 years ago are suddenly much more important. And so I've had to update my plan fairly recently. And so that's why estate planning is important to me, but there's more to it than the money. And just making sure that all that money is there available to them. You know, if I was given a choice and I could only leave my kids one of two things, and those two things that I had to choose from were all the money that would be available to them if I died today. And I should tell you, if you were filling out, when I'm applying for a mortgage, I look pretty poor because they eat every nickel I make before I even make it. But I also happen to have a father who had a State Farm life insurance agency for 40 years that my brother just took over. So I get sold life insurance every time there's a family dinner, right? So the old adage of being worth more dead than alive, that happens to be true for most of us. It's certainly true for me. I make sure my kids aren't aware of that fact so I don't have to sleep with one eye open at night. But there'd be a lot of this money coming in. And if I had to choose between leaving them all of this money that would be available when I die for their care, or all of the values that have been instilled in me by my parents and my grandparents and my teachers and my Bible school teachers and my coaches and my mentors at work, well, that's a simple choice for me, right? My kids wouldn't get a dime. They'd hopefully learn all of these values that have been taught to me. And there's a couple of reasons for that. One, I think those values are much more important. And two, if they want to make money, I think the values will help them do just that, if that's their goal in life. But those values are much more important. So despite being, by any metric that any fundraiser, development officer at any organization would ever use, I'm the worst, what's often referred to as plan giving prospect you will ever meet. The idea of leaving an estate gift of some kind to any organization seems like a bit of a pipe dream because I'm too young to be having those discussions. I've got too many kids. They eat too much. And so the chances of me building wealth are small, right? Despite all of those issues that would exist, there's a planned gift in my estate plan. And it's not very big. It's not going to mean much to the organization that receives it if I die today. Hopefully it'll grow in value over time, so it might be a little bit more meaningful when I actually do pass away. But that's not even the point to some extent. I do love that organization, but that's not really the point. The point is to set an example for these four. So the guardian of my kids, if something were to happen to me in the short term, can point back and say, look, these are all the things your father wanted for you, and this was so important to him that he included it in the last financial transaction that he ever controlled, in addition to making sure you were taken care of. I know he would want for you to think the same way, to do the same things with the resources you're blessed with throughout your life, because that is important to me. So you've got to think about what's important to you. Why is estate plan important to you? There's a simple kind of hypothetical question that I, many years ago, began asking of all of the people that I work with to maybe help set some context for what you think is important to you, because these aren't questions that a lot of us think about very often. We don't like to think about our own mortality. right? We don't like to think about what's going to happen after we're gone very often. We like to keep building. We're pretty good at that. We like to keep making money. We don't like to stop and think about what's going to happen with it when we're gone very often. So there's a simple hypothetical question that hopefully isn't too scary to help you maybe set some context around and start the conversations that maybe you have with yourself or with your spouse about what is important to you and what your estate plan should look like. And that hypothetical question goes something like this. If you were suddenly given a large sum of money, and that's intentionally relative because it'll mean different things to different people depending on your own financial situation, but maybe that's $100,000. Maybe it's $1 million. Maybe it's $10 million or more. But whatever a large sum of money is to you, if you were suddenly given that large sum of money, and there were two stipulations with what you could do with that sum of money. The first stipulation was you could not spend it in any way on yourself or your spouse, so it had to go somewhere else. And the second stipulation is you have to do something with it right now. What would you do with that large sum of money? And I'm always interested by the answers I get to that question when people have some time to think about it. Sometimes I'll have people say, well, I don't know, Jeremy, I guess I would just leave it all to my kids. But that's not the majority of the answers that I get. The majority of the time, the answer goes something like this. Maybe this is something similar to what you were thinking to yourself. He goes, well, there's certain things I'd want to help my kids out with. That tends to be where they start if they've got children. It tends to be, I'd want to help my kids out with, and often it's related to getting them out of debt, right? It's, they bought more house than they can afford, and they've got to drive nicer cars than they can afford, and man, I don't know how they're paying for all this stuff, or they're going to do this in the future, and man, inflation's looking bad, and all this kind of stuff. If I could help them get to a point where they could stop worrying about money and start maybe building some wealth on their own so they could do some things, that would be great. That's what I would want to help them with. But I wouldn't want to do much more than that because I want them to be productive. And then if you have grandkids, I often hear things like, and I'd like to set a little bit aside from that chunk of money for my grandkids' college education. That seems to be getting more and more expensive. And so if I could do that, that'd be great. I'd love to help with that. But most of the time, it doesn't go much beyond that when it comes to the grandkids or maybe nieces and nephews or other family members. And then they say something like, and then I'd want to make sure there's some left over so I could start a mission fund at my church, set up a scholarship at my alma mater so that kids that maybe don't have those resources that I did or that opportunity that I did to get an education could do that. Or maybe set up a fund for cancer research because that took my parents. And if we could cure that disease, that would be great. Or maybe at my local community hospital that was so great at treating me when I was going through my illness. Or maybe it's this that I'm involved in or this other group that I'm involved in. And they start listing off these things that they're passionate about, that they want to include in this transfer of money in addition to their family. So I stop when they're done and I ask a second hypothetical question. I'll ask it of you. God forbid the last hour or so of your life is spent listening to an attorney talk about death and taxes and you die on the way home, right? Is that what your estate plan says to do? Does your estate plan match the answer you gave to my first hypothetical question? Because if you do happen to die on the way back home after our little presentation today, the situations are suddenly identical to my first question. Suddenly you'll have a large sum of money, almost certainly larger than any single sum of money you've ever controlled at one time. Probably, based on my experience, a much larger sum of money than you even realize. And there are only two stipulations on what you can do with that large sum of money. One, you can't spend it on yourself. And two, you got to do something with it right then. Why doesn't your estate plan match the answer you gave to my first question? Because I think this is the truth. The answer you gave to my first question is your estate plan. You just maybe haven't put it on paper yet. And maybe that's because attorneys are scary and we're all crooks. Nobody wants to talk to us. Maybe it's because you don't like talking about death and taxes. Maybe it's because you don't want to think about it and you hadn't taken the time. But whatever it is, your answer to my first question is your estate plan. What we want to help you figure out is, how do you put that down on paper? How do you make sure that that's what actually happens when the time comes, whether it is on the ride home today or hopefully many, many years from now? All right? I think that's critically important to understand. Why is estate planning important to you? And then once you figure out why it's important to you, what are some of the things you need to know to make sure that your plan does do what you want it to do? Why is it important to have a will? And I'm using the term will generically here because it's the most common document that's used to describe the distribution of assets. It's the thing that most people understand when you're talking about an estate plan. But your estate plan may include trusts. It almost certainly includes things like beneficiary designations and a variety of other issues and items that ultimately control the distribution of your assets at the time of your death. But why is it important to have these things done? And the first reason is the simplest reason, right? To outline where you want your stuff to go when you die, to control the disposal of your property at your death. You may not be aware of this, but everybody in this room has a will, in effect, whether you've drafted one or not, because every state in the Union has what we refer to as intestacy laws, right? Laws that describe where your stuff goes when you die if you haven't described it yourself in a last will and testament. And you may not be real happy with the way the state of Tennessee or the state of Mississippi, or maybe even Arkansas, some of you may live that way too, you may not be real happy with the way those states describe where your stuff's supposed to go when you die. Let me give you a quick example. Wonderful state of Tennessee, right? You might think that if you were married and had kids, that if you died, everything would go to your spouse, your surviving spouse. But that's not what the laws of the state say. Everything you own individually, right? So you've got a business that you started that's done pretty well, or maybe you got some property, or maybe you've inherited something that you've kept in your name. But the laws of Tennessee say that if you're married and you got kids, when you die, your spouse is entitled to the greater of 1/3 of your property or a child's share. So if you've got 2 or more kids, 1/3 is what you're getting. The other 2/3 is distributed equally and immediately amongst your children. That's probably not what you want to have happen. And so making sure that you do have a document, a legal document, a will, a trust, whatever it might be, that outlines where you want your stuff to go when you die is pretty important, instead of allowing the state to describe that for you. So avoiding that issue of intestacy, dying without a will, right? Making sure you've got the right people named to serve in the right roles, whatever the roles are that need to be filled in your particular case. If you've got minor kids, you may need to name guardians. If you're a custodian of someone, you may need to name an alternate guardian. Doesn't have to be minors. Maybe it's an aging parent, right, or a loved one with special needs. Making sure you've got the right guardian's name. Make sure you've got executors' name that are going to deal with everything when you're gone, and make sure it's all distributed according to your will. Making sure you've got trustees, the right trustees named, if you need trust as part of your plan, because you're leaving assets to minor kids, like in my case, or maybe to people who can't handle a large sum of money. Or, most commonly, it's not your kid, right? It's that evil son-in-law. We all know that, right? That's whispering in your beautiful daughter's ear the whole time about how they spend the money. Whatever it is, maybe you need some trust language, but maybe there are other issues like taxes, or maybe you're part of a blended family and you've got some concerns there that you want to make sure that are dealt with. Trusts are a lot less scary than a lot of people often make them out to be. And a lot more common, and often, in my experience, a lot more necessary in certain circumstances than people realize. So making sure that you've got those trusts, if needed, to protect the beneficiaries, or even what's become even more common in my experience recently, is not necessarily to establish trust to protect the beneficiaries, because maybe the beneficiaries are doing fine, and maybe they're mature, and maybe they got good heads on their shoulders, and maybe their marriages are going okay, and everything looks all right. And so you're not concerned about what would happen if you left them a big chunk of money, but there's always all of those things around them that could come after that sum of money that you leave to them. Right? There's 3 evils we attorneys like to talk about: creditors, predators, and evil in-laws. right, that could come after your stuff. And if you leave somebody an inheritance outright, well, then any of those three things can come after all of that stuff, right? But if you leave that inheritance to those beneficiaries in trust, right, then that trust can protect that inheritance from all three of those things. So if they're driving down the road on a wet and rainy day and rear end somebody and get sued for all their worth, that person can come after all their personal assets, but that inheritance you left them will be protected in that trust so they don't get completely wiped out. Or if there's another 2008 type recession, kind of out of the blue, and they lose their job, suddenly they got creditor problems they weren't expecting. Those creditors are going to come after all those personal assets or whatever assets are securing those loans, but they can't come after that inheritance and trust. Or is becoming more and more frequent, let's say the spouse goes off the rails and the marriage fails. That divorcing spouse is going to come after at least half of the stuff, but they can't come after that inheritance that's left in a well-drafted trust. Now, trusts come at a cost, and so there's an analysis there that you got to run, a cost-benefit analysis. How much are you leaving, and what's the benefits, and all that kind of fun stuff. But that may be something that you've never even thought about as part of your plan. That may make your plan much more your plan than it was before. Minimizing death taxes and other costs. We're going to spend a little bit more time on taxes here in just a minute, right? I've been talking about death. I've got to talk about taxes too, right? The good news is the death tax is not a huge concern for most people anymore, but taxes certainly are, so we'll talk about that. Avoiding ancillary probate, that's a really fancy term we attorneys like to use for leaving an estate in which more than one probate process is going to be required, basically. And the bottom line is this, to a large extent, if you happen to own real estate in more than one state, right, like you live here in Tennessee and you got the duck hunting land in Arkansas and you inherited the family farm in Kentucky and you bought the vacation condo in Florida, your heirs will have to open up a probate estate in the state in which you reside at the time of your death to deal with most of your stuff, but they'll also have to open up a probate estate in every state in which you own an interest in real property, a deeded interest in real property. That may be a timeshare, right? And so suddenly, where probate in Tennessee, if everybody gets along, may not be that big of a deal. You may not want to go through a whole lot of rigmarole to try and avoid probate just here in Tennessee, but you start multiplying probates and multiplying courts and multiplying judges and multiplying attorneys, maybe avoiding probate becomes a higher priority. And then these last two, creating a family legacy and passing on your values as well as your valuables, are the elements that are almost always left out of an estate plan. And that's largely because most of the time an estate plan is treated like going to the dentist, right? It's something you dread, and you want to get in and get out as quickly as possible so you can check that box off the list of things that makes you a responsible adult and move on with your life and never think about it again, right? And that's why the most common reason people walk into my office in Nashville to get wills done is because they're about to hop on a plane, maybe to travel overseas in a couple of weeks, and so they want to make sure they've got something down on paper just in case the plane goes down. Of course, the first thing I tell them is statistically they're more likely to die driving to my office to sign their wills than they are, on that plane. But nobody wants to hear that, right? And so they have put zero thought into what they can accomplish. Zero thought in what they actually want to do. And it's funny to me because they're already sweating before they walk into my office, right? Because they're already scared of walking into an office alone with an attorney, right? And they're looking at a watch that they don't wear anymore because nobody wears watches anymore because they know the meter's running the whole time and they want to get out of there as quickly as possible. And so it's a very short, very quick conversation. And they're almost sprinting when I say, okay, I've got everything I need out the door, right? But this is, and this is the point I try to emphasize as much as I can, this is, for nearly all of us, the single largest financial transaction we will ever control at one time. The old adage of being worth more dead than alive is true for nearly all of us, at least financially. For some of us, it may be more than that. And so this is, with your estate plan, the single greatest opportunity you will have to make a financial impact on the people that you love the most and on the causes you believe in the most. And it may also be the greatest opportunity that the government has to step in and take a chunk too. It also happens to be your final transaction. And so for all of those reasons, I kind of feel like this is something that maybe we ought to put a little bit more thought into than we typically do. A little bit more thought than driving by my office and saying, hey, Jeremy, I'm hopping on a plane in a couple of weeks. I need to get a will done before I get on that plane just in case the plane goes down. Can you get me something up? Great, here's my name, here's my wife's name, here's my kids' names. Great, I'll be back in a couple of weeks to sign something. Right? And so that's what a good estate plan should be. That's why you should get one. What are some of the common mistakes that I see in estate plans that cause even good estate plans to go awry? Some of these are pretty simple and straightforward. Not listing alternates and planning documents, that's a common one, right? Getting your will done, again, is one of those things you do and then you don't think about it again. So a lot of the times when people in the past have walked into my office and said, hey, Jeremy, Mom just died, I need help probating her will, right? It takes like a crowbar to pry the will open, unfold it, right? Because it's been sitting smashed in a filing cabinet for a couple of decades. The paper's yellow, right? And not only do we have to kind of use a crowbar to pry it open, we've got to be real gentle when we do because the paper's already fallen apart, just about. And what do we find out? Well, the executor they named in that will to help deal with the estate when they were gone was a friend of theirs who was the same age. And if Mom died at 93, you can imagine where that friend is, right? And they didn't have an alternate named, so we've got a bit of a problem. The problem is that will's worth less than the paper it's printed on at that point. So making sure you've got the right people named, you've got alternates named, all of these things are important. No tax planning when it's needed. That's become less of an issue for a lot of people, but still an issue for some. No business succession planning, see that all the time. Certainly no charitable planning. It's the last thing people tend to think about when they go to get their will done, even though and even for the people for whom charitable planning is an important part of their financial life throughout adulthood. I'm always shocked by when people come to my office that I know are incredibly generous with their time and their resources. They budget for giving back in some way to their church and to other organizations. And then when it comes to the single largest financial transaction that they'll ever control, they just kind of go, I don't know, I guess I want it all to go to my kids. They would never, ever do that with any large sum of money at any other point in their life, and yet they're perfectly fine with doing it at their death. It's not consistent. And that's fine if that's what they really want, but in my experience, it's not consistent primarily because they haven't put any thought into it. And when they do think about it and they do realize what it means, they suddenly change their minds about what they want to do in their estate plan. Right? And then I skipped over a couple because these are the most common, and these are the most common mistakes I see that create some of the biggest problems when it comes to the distribution of assets. And I want to make sure that I spend a little bit of time on those. And that's wrong beneficiary designations and mistitling of assets. And they're kind of two different parts of the same issue. And it kind of boils down to this. Right? And that is when you die, assets are distributed in one of two ways generally. They're either distributed through the probate process or they're distributed outside of the probate process. And all the probate process is the court-supervised, statutorily defined process that we have in our country for transferring a deceased person's stuff from that deceased person to whoever's entitled to receive it when that person is gone. That's all the probate process is. And kind of in a nutshell, the way it works is if you've got a will, if you don't have a will, right, there's laws in every state that kind of describe where things are supposed to go. If you've got a will, the will describes where you want stuff to go. And what happens then is that will is admitted to a probate judge or maybe the county probate clerk, depending on how that county works. And they review that will. They make sure it meets all the legal requirements of a last will and testament. They make sure that you're actually dead. And then they admit that will to probate. And what's called a probate estate is opened up in the name of the deceased person. And then an executor is appointed by that court to represent that deceased person's estate and make sure things are done the way they're supposed to. Typically, that's someone named in the last will and testament. That executor is then charged with collecting all of the deceased person's stuff, right? Most states, they've got to post a bond, right, to secure that stuff, but that can be waived pretty easily. It can be waived in a last will and testament. So if you think it's unnecessary, that's an expense that doesn't need to occur, right? But they've got to collect and take charge of all the deceased person's stuff, and then they got to make sure it's all distributed where it's supposed to go. And as you can probably imagine, the government gets its share first if it's owed anything. Your debtors get their share if you have any debts, and then whatever's left gets distributed to your heirs according to your last will and testament, or according to the laws of the state if you don't have one. And that's the probate process in a nutshell. Now, even in the best of circumstances, and Tennessee happens to be a pretty easy probate state, comparatively speaking, it's not a fun process. It's tedious. There's all these little statutory requirements you got to follow, but for the most part, it's just paper pushing over about a 9-month to 12-month period. Yes?
Hypothetically speaking, if you have more debt, then you can pay back with your whatever you own.
Yep.
Do your kids owe that debt back?
No. With a caveat, I mean, it kind of depends on what the debt is, right? If the debt's attached or secured by a piece of property, then it continues with that piece of property. But they wouldn't have to pay beyond that. They'd short sell it or let the bank foreclose on it.
Credit card, student loan debt, that sort of stuff.
That does not. Yes. If that wasn't heard in the front, personal debt, credit cards, student loans, that does not. So that's kind of the probate process in a nutshell. All right, now again, it takes time. It takes some effort, right? But as long as nobody's fighting, it tends to not be that big of a deal. As long as there's not anything weird happening with the actual assets or certain debtors or whatever it might be. Now, once anybody starts fighting, the only people that win are the attorneys, right? Then it can drag on forever and be really expensive. And, once you get an attorney involved that bills by the hour, you can just imagine what their incentive is, right? It's to keep the fight going. So if you want to be real cynical, you can just imagine where all that money goes, and goes really quickly. But that's the probate process. Now here is the important thing to understand. A last will and testament only controls the distribution of assets that become part of the probate estate, that go through the probate process. A last will and testament is basically just an instruction manual for the probate process, for the executor to follow. And that's a common misperception that a lot of people have. They'll come into my office and say, Jeremy, well, I've got a will, I don't have to worry about probate. Well, the opposite is actually true. For that will to have any power or effect, it has to be admitted to probate, and it is just an instruction manual for that probate process. What that also means, conversely, is that anything that is transferred at your death outside of that probate process is not controlled by your will, and that leads to one of the most common planning mistakes that I see. And I'll give you a quick example using myself, right? When I got out of law school, I pulled my dad into my office and said, all right, Dad, I'm a newly minted attorney. You're going to be my first client because hopefully you won't sue me if all this goes wrong. I'm not entirely certain that's the case, but that was my thought. So I brought him in, and he brought in his old wills, and I started reviewing them. And, my dad, he got married and started a business and had his first child, and he did what he thought was responsible and ran off to an attorney buddy of his and got a will done. And then he had child number 2, and he ran off to his attorney, said, do I need to update anything? And got his will updated. And about that time, he started his State Farm agency. So he thought to himself, well, I probably need to make sure there's some actual money there for my kids to be taken care of. So he bought himself a really big life insurance policy, right? A couple $1 million from himself, so he made his production quotas that year, and he took care of his family, right? And then he had child number 3, and he went running back to his attorney. Child number 4, same thing. Child number 5, same thing. So I pulled out that will, and the will looked fine. There were a couple things that probably needed to be updated, but the will was in pretty good shape. I said, Dad, this all looks great. Let's take a look at your life insurance policy. And he said, why? And I said, well, your life insurance proceeds when you die are controlled by that beneficiary designation. That's a contract with the life insurance company. It doesn't have to go through probate, which can be a good thing. But what it also means is it's not controlled by your will. And so we pulled out that life insurance policy. Sure enough, the beneficiary designations were my mother first, and then the oldest child, and only the oldest child listed as a secondary beneficiary. So if my mom and dad had gone on a date that evening and died together in a car accident, the only person who would have gotten all of that life insurance money was the oldest child, and only the oldest child out of the 5. And so I said, Dad, this looks perfect, because I'm the oldest child, right? Everything looks good. We've got it all together, right? And what I really did was explain to him this issue. That's a huge and incredibly common planning mistake, right? Because he ran back to his attorney. His attorney got his will updated. His will talked about all of his kids. He thought his will was going to take care of everything. He didn't realize he needed to run back to his life insurance agent's office himself and update life insurance beneficiaries. And then we looked at his IRA. He didn't realize he needed to run back to his financial advisor's office and update the beneficiaries on his IRA, right? And maybe you've got a 401k at work. You didn't realize you need to go running back to your HR department at work to update your 401k beneficiaries. And oh, by the way, that savings account you put daughter Susie on so that she could write checks as you get a little bit older to make sure your bills are paid just in case you don't remember. Well, that all is going to daughter Susie, and none of the siblings are getting that either, so now Susie's the bad guy. And so you end up with stuff all over the place despite having a perfectly well-drafted last will and testament, right? Incredibly common planning mistake, easy thing to fix in most circumstances. Changing beneficiary designations is pretty easy. You can do that for free in most circumstances, right? Pretty easy thing to do, but far and away the most common planning mistake that I see. Now, what it also leads to is this. Once you become aware of this situation, it also leads to a planning opportunity, right? Because I can have a last will and testament that says I leave everything in equal shares to my 4 kids in trust until they reach this age, and here's the trustee, and da-da-da-da-da. And I can name my estate or the trust under my will as the beneficiaries of my life insurance policy and my retirement accounts, so that all of that money, in addition to my home and my checking account and my savings account and all the assets that are just in my name that would go through probate, it all ends up in my probate estate, so that it all goes into these trusts for my kids just the way that I want. But I may want to also leave a little something to my favorite nephew. Or maybe leave a little something to my church or my alma mater or some other charity that I'm heavily involved in. And I can do that very easily by simply changing a beneficiary designation on a life insurance policy or my IRA account, and just leave a small percentage to each one of those people or places. And if I change my mind because my nephew ticks me off, I can cut him out real quick, right? I don't have to go back to my attorney and update my will and pay a fee and go through that whole rigmarole. I can very easily redirect monies pretty quickly using these beneficiary designations if it matches my intent. And so that becomes an important thing to understand. You've got to make sure that not only you have the right legal documents in place that are drafted properly, but that all of your assets are coordinated with whatever that overall plan may be. It doesn't mean it has to be coordinated with that legal document. It has to be coordinated with whatever your plan may be. You may want to direct certain assets away from what the legal document says, and that's perfectly fine. But what happens too often is they get directed away from what the legal document says, not through intent, but by accident. And that leads to a distribution that's very different than what most people expect or what they want. All right. I warned you. We've been talking about death. I warned you we were going to talk about taxes, so here we go. When you die, this does become an opportunity for the government to take a big chunk. And there are two separate sections of the tax code that could significantly impact this transfer of assets at the time of your death. One section is the transfer tax section. You may not be aware of this, but the government of the United States does tax your ability to give your stuff to someone else. What's called a transfer tax. It's different than the tax we're all very familiar with, the income tax, right, which is a tax on the income we earn or bring in for ourselves. The government does tax you when you try to give your stuff away to someone else, right? And the tax that we may or may be familiar with, and that is a transfer tax, is this dreaded death tax, the estate tax, right? But it is, I think, important to understand how it works a little bit. It is a transfer tax, so everything you control the distribution of at the time of your death is all valued and added up, and then your debts are subtracted from that. And that basically leaves you with your taxable estate. That's how much value you're transferring at the time of your death. Right? Now, that includes things that you may not consider as part of your net worth while you're alive. For example, term life insurance policies that are in effect at your death. Right? My 4 kids eat everything that I make before I can make it. Right? The idea of building net worth seems like a bit of a pipe dream to me. I'm going to be paying Vanderbilt back for the rest of my life for my law school education. These school loans are ridiculous, right? When I go in to apply for a mortgage, I'm not a great client. But I've got life insurance coming out my ears. When I die, my kids are going to be millionaires. For estate tax purposes, when I die, I am a millionaire. Because I control where all of that money goes when I die, even though I can't touch it at all while I'm alive. So when we start talking about some of these big numbers, it's not as hard to get to some of these numbers at your death as you may realize. Things like the equity in your home. When I first started in the estate planning business, most of my clients were dairy farmers in Murfreesboro, if you know the greater Nashville area, right? They would walk in, I'd be sitting in a conference room, right? I remember one couple in particular. I was sitting in a conference room at a bank in downtown Murfreesboro. The conference room table looked like it was worth as much as my house, right? The gentleman's banker and his financial advisor and one of the town councilmen was sitting around the table with me. I don't know why he was there. Just trying to figure out where his town's land was going, I guess, right? And the client walked in, he and his wife walked in their overalls, right? Literally with cow manure just coating them because they had just come out of the fields and barn, milking the cows, sat down across the table and we started talking. And they told me their story, right? We bought our farm 50 years ago for, I think they said $60,000, which was a massive amount of money at the time, but they had inherited some money and wanted to get into farming. They bought this dairy farm on the outskirts of this little bitty town called Murfreesboro, right? 50 years ago. And they had worked from before sun up till after sundown for their entire lives and never had 2 nickels to rub together. So I kind of asked, well, then why are we all here? And he looked at me and said, well, now my banker's telling me my land's worth $10 million. And I'm going to owe $3 million in estate taxes when I die. And I don't have there's no way my kids can pay that. We're going to have to sell the family farm, pay the taxes, right? So in his mind, his farm was worth $60,000. That's not what the IRS was going to tell his heirs when he died, right? So again, the old adage of being worth more dead than alive, at least financially, is true for nearly all of us. And that number that I'm talking about for you is probably bigger than you even realize when we're talking about these transfers. And the government does tax your ability to transfer that money. Now, there are a couple of major deductions to offset that tax. And the good news is we currently have the most generous estate tax law that we've ever had as of a couple of years ago, right? And what I mean by that is we have the largest exemption amount, the amount you can pass free of estate tax to whomever you want, that we've ever had in the history of the estate tax. Currently stands at $11.7 million per person. So if you're married, you can double that. That's a massive number. Not many of us have to worry about the estate tax anymore. Now, if you happen to be worth more than that exemption amount, it's still a massive tax. It's still 40% on every dollar over that amount. But to put that in some context, when I started in this business a couple decades ago, that exemption amount was $600,000 with a top tax rate of 55% on everything over that amount, which meant the fear of losing half your stuff to taxes when you died was very, very real for a lot of people back then. That dairy farmer, at the time, the exemption was $1 million. Very real for a lot of people back then. Not so much now. Now, for what it's worth, that exemption is scheduled to sunset of its own accord. The law goes away if Congress doesn't do something different before 2026, at which point we fall back to what will be roughly a $6 million exemption per person. Still a really big number, but roughly cut in half. And that's if Congress doesn't change the law on us before then, which they like to do because attorney lobbies are pretty strong. And if we keep changing the law on you, you have to keep coming back to us and paying us to update stuff, right? So who knows what Congress is going to do in the meantime, but that's where the law currently stands. So that's, I guess, the good news, right? And I'm going to go through this really quickly because not many of us have to worry about the estate tax with these current exemptions, but I do think it's important to understand. If you happen to have an estate, and I hesitate to use the word wealthy because, again, my dairy farmer client didn't consider himself wealthy at all. He couldn't write you a check for $100 if you asked him for it. But he had an estate tax problem. So, if you happen to have an estate worth enough to have an estate tax problem, I do think it's important to understand that there's only 3 major deductions at the time of your death to offset that estate tax. We've talked about that exemption amount, but if your estate is worth more than what can be exempted, that only leaves 2. One is the unlimited marital deduction. So you can leave as much to your surviving spouse as you want, but that's just the delay tactic, right? Eventually both of you are going to be gone. And really that's what the estate tax is about. It's about transferring taxes from one generation to the next. We don't want your family to amass all the wealth and then give it to the next generation who amasses a bunch more on top of it, and then suddenly we've fallen into the old feudal system by default that we rebelled against as a nation a couple hundred years ago. So if you become too wealthy, whatever that happens to mean at the time to Congress, we're going to tax you, right? So the marital deduction exists, but it's only delayed, and that leaves one and only one remaining significant deduction at the time of your death to offset the estate tax if you don't want to pay that 40% tax to the United States government. And that's the unlimited charitable deduction. That's an eye-opening statement for all of my clients, regardless of their economic status or their sophistication when it comes to financial matters. Because that's not something attorneys talk about very frequently. But the flip side of that is, because it is an unlimited charitable deduction, the estate tax is an entirely voluntary tax. Nobody has to pay it. If you're comfortable leaving the exemption amount, whatever it may be, currently, again, if you're married, a combined $23.4 million to your heirs, you can leave everything else to charity, and Uncle Sam won't get a single penny from your estate. It's a completely voluntary tax, right? But I think that's important to understand. The second tax is the tax I'm going to focus on to finish out the presentation today because it's the tax that affects a whole lot more of us. Ironically, it's both the tax we're very familiar with and the tax that never gets discussed when you go to get your will done, and that's the income tax. And the reason why it's never discussed, I think, is twofold. One, it's not what your attorney does. Two, the general rule is that an inheritance is not taxed as income, so your attorney doesn't need to do anything with it. So that's the good news. The bad news is that, like most general rules, there's an exception. And that exception, while it didn't used to apply to very many people a few decades ago, now applies to nearly all of us. And that exception is for what's referred to in the tax code as income in respect of a decedent, or IRD assets, which is really kind of a fancy word for saying all of your wonderful tax-deferred retirement plans, like traditional IRAs and 401ks and 403b plans and TIAA CREF and all of that stuff. Or to a lesser extent, tax-deferred annuities, U.S. savings bonds, all of these assets that have tax-deferred elements to them that would be taxed as ordinary income, not long-term capital gains. So we're not talking about your house that's appreciated in value, or your rental property that's appreciated in value, or even the stock that you bought in Apple, or the whatever it might be, the mutual funds, right? In fact, the good news is, in relation to those long-term capital gain assets, when you die at least, and you leave those to your heirs, they get what's referred to as a step up in tax basis to fair market value. So their basis in that appreciated asset when they inherit it becomes whatever it's worth when they inherit it, which means all the capital gain is effectively wiped away. They can liquidate the whole pool of assets and pay zero tax, turn it into a big wad of cash, tax-free. Right? But the exception are for these income tax deferred assets. Again, primarily IRAs, 401ks, not the Roth versions, the traditional versions, right? Where you draw from them in retirement and you've got to treat it as ordinary income. That ordinary income tax element never goes away. You leave those IRAs or those 401ks to your heirs, they've still got to pay the taxes. You leave it to a trust for your heirs, the trust has to pay the taxes. That ordinary income tax element is never going away. So, and for what it's worth, if you happen to have an estate that's large enough to have an estate tax liability because it's worth more than the exemption, then to the extent it's worth more than the exemption, those IRA accounts will effectively get double taxed. They will be taxed at 40% for estate tax purposes and then taxed again as income when your heirs take distributions. They could lose as much as 65 to 70% of the value of those accounts in combined taxes. And under the Secure Act that was passed not too long ago, your heirs don't have the ability to spread the payments out from those accounts like they used to. It used to be that when a non-spouse beneficiary, a child, for example, inherited an IRA from their parents, they could spread the payments out from that IRA over their remaining life expectancy. So if I was 50 when I inherited my dad's IRA account, I'd look at the nice little table that the IRS puts out that tells me how long I'm going to live, and I can spread out payments over whatever's left, which typically would be pretty small payments early on, unless I needed them, and I would only pay income taxes on those small payments. And the bulk of the investments would stay in that tax-deferred investment environment. And that was good for me, unless I actually needed to pull the money out. Now, however, I have to take all of that money out within a 10-year period and pay all the taxes back to the federal government. Right? So those are your taxable assets. Right? And so we're going to focus on those for a few minutes because those are the ones that most of us have to deal with from a tax perspective, and there's some planning that can be done to avoid those taxes, especially if we've got some charitable intent. And the first thing I'm going to talk about is using those assets while you're alive. Right? There's a law that was passed roughly 10 years ago, maybe a little bit more than that, that's commonly referred to as the Qualified Charitable Distribution Law. And what that means for me, if I'm an IRA owner, is this. I can now use those accounts to make charitable gifts in a way that I could not before. Prior to the passage of this law, in order for me to use all of this money that I had tied up in my retirement accounts, I had to take the money out and treat it as income because I took it out. So I had to report it on my 1040, which means I had to pay taxes on it. And then I could turn around and write a check to my favorite charity or group of charities. And if I could use the deduction, if I itemized, and if I could use that full deduction, I would offset all the taxes on the amount I pulled out. But if I couldn't, because I used a standard deduction, I don't itemize, I couldn't use all my itemized deductions that year for some reason under the law, whatever it might be, I would end up paying taxes on my gift, effectively. Which meant those IRAs and those 401ks and the like weren't very good pools of money for me to use to make charitable gifts while I was alive. Until they passed this law. Now, there are a couple qualifications here when it comes to the Charitable Ira Rollover. One, you have to be over 70 and a half. Now, I know the RMD rules changed recently, and you don't have to start taking required minimum distributions until you're 72, but they didn't update the qualified charitable distribution law, so you can still start doing it at 70 and a half. Now, as you'll learn in a second, it makes the most sense after 72, but you can start it earlier if you choose to. It has to be an IRA account. You can't use, right now at least, under the current version of law, you can't use 401ks, you can't use 403bs or anything else. It has to be an IRA account. And you have to use it to make gifts directly to a qualified charity, a public charity. So things like private foundations and donor-advised funds don't work, right? But if you've got an IRA account and this can be a great option. Because now what the law allows is for you to direct money from your IRA account directly to a public charity, and it effectively avoids you altogether. And it counts towards whatever your required minimum distribution was for that year. So, if I had $100,000 in an IRA account, and my required minimum distribution for that year was $3,000, I could, instead of taking that $3,000 and paying taxes on it and then throwing the remainder in a savings account if I didn't need it, I could direct that $3,000 to go immediately to my church or my favorite charity or any favorite charities I wanted to give to, and that $3,000 would bypass me altogether. It would go directly to those organizations which are tax exempt, so they pay no taxes on that amount. So effectively, I get the tax deduction, and it counts as my RMD, so I don't have to take more out and pay taxes on it, and I don't have to itemize my deductions, so I can still file a simple return and take just a standard deduction and get that. So if I happen to fall into that category, non-itemizer, simple deduction, over 72, have to take RMDs. I typically tell my clients that's the first place I want to start making my significant gifts from. Up to whatever my required distribution is for that year, my gifts need to come directly from that IRA account to those charities using a qualified charitable distribution so that I can effectively get deductions for those gifts without having to itemize. That's an important thing. Again, the main qualifications, over 70 and a half, has to be an IRA, and you can make an aggregate in 1 year of up to $100,000 of gifts, which is a really big number, so that's pretty nice. Now, before I finish talking about IRAs, I want to make one last kind of contextual point based on everything we've talked about to this point in our presentation. And that is this idea of 3 buckets. When you die, there are basically 3 buckets you can pour your stuff into. You can pour it into your heirs bucket, kids, grandkids, nieces, nephews, family, friends, whomever those people may be. You can pour it into the government's bucket through some form of tax, and as you may have learned, nearly all of us have some type of tax liability built into our estates in some way, either because we've been blessed enough to have an estate larger than the exemption, so we've got an estate tax problem, or maybe we've put some investments in a qualified plan like an IRA or 401k, so we have an income tax issue on a specific group of assets, even though everything else will be tax-free, or maybe we have both. But whatever it is, the government is probably going to step in and take a chunk. Or we could pour some of it into charities bucket, causes that we believe in, causes that we want to support. Now, here's the point I like to make. Nearly all of us have a plan that says, I want to leave 100% of what I'm worth to my heirs bucket. I'm going to pour it all in there. Now, that's true because roughly 60% of Americans who die every year don't have a will at all. So they have that plan by default. The overwhelming majority of that minority group that have a plan when they die have some version of what the attorneys refer to as the simple I love you plan, right? If I'm married and got kids, it would be everything to my spouse and then to my kids in equal shares. Now here's the dirty little secret most attorneys don't tell you, right? That even if you're a very wealthy individual or couple and you went to the best estate planning attorney in all of the greater Memphis area and you paid $15,000 for the best estate plan that money could buy from the best estate planning attorney in your town, it is almost certainly a 6-inch thick version of the I Love You plan. Now, sure, it's got some estate tax planning in it, and it's got some trust planning for the kids, and generation skipping trust, and all this other fun stuff in there, but it's still just a really expensive version of the I Love You plan when you boil it down. And you're still dealing with those 3 deductions that I mentioned. The marital deduction, the estate tax exemption amount, and the charitable deduction. And that's it. So you're still going to end up pouring some into the heirs bucket, some into the government's bucket, and in that case, 0 to charity because it's not included in your plan. And so that brings up this question that I ask of everybody: how strongly do you feel about the government's bucket? Because that's an important question. If something from your estate's going to get poured into that, how strongly do you feel about it? Because it's voluntary. And I get a variety of responses. And I think this is really important. Some people will tell me, Jeremy, I'm okay with the government getting a little bit, but I want to make sure I get as much as I can as quickly as possible to my heirs. And if that means they pay more in taxes, I'm okay with that. And if that's how you feel, we can help you plan accordingly. On the other end of the spectrum are the people that tell me, Jeremy, Uncle Sam's gotten every penny out of me that he deserves. I want to be able to control where all my money goes and how it's used after I'm gone. If that means my heirs get a little bit less, but more of my money goes to causes that I want to support, including my kids, that's what I want to do. If that's how you feel, we can help you plan accordingly. A whole lot of people, if not the majority of people that I talk to, tend to fall somewhere in between. And the response is something like, well, Jeremy, I don't like the idea of Uncle Sam getting more from my estate after I'm gone, or my heirs paying more in taxes on what they inherit after I'm gone. If I could shift some of that to causes I'm already supporting, that would be great, but I don't want to take too much away from what my heirs get either, so what does that look like? And that becomes a pretty hard discussion to have, or at least a deep one. It's one that almost nobody has ever had in relation to their estate plan. But once we figure out where they fall on that continuum, the truth is, planning to get to that point is pretty easy. We've only got so many tools in our toolbox. But nobody puts that kind of thought or discussion into their estate plan before they walk into their attorney's office and say, well, I don't know, I need to get my will done. But that becomes a critical part of the discussion in determining what is best for your estate plan. And it basically boils down to this. For most people, you've got a pool of assets, and I do have a little pointer right up here, that will be taxable, that we've talked about. All these deferred tax assets, IRAs and 401ks, and everything else will be basically tax-free to whomever you leave them to. While you've also got a pool of beneficiaries down here that will have to pay taxes. You've got a pool of beneficiaries potentially in the form of charities that are tax-exempt. Well, obviously, what we don't want to do is this. We don't want to send the taxable stuff to the taxable people and then send some of the tax-free stuff to the tax-exempt people. That's backwards, right? Because we end up including Uncle Sam, as an unintended beneficiary of our estate. What we want to do is the opposite. We want to send the taxable stuff to the tax-exempt people and the tax-free stuff to the taxable people as much as we can while still fulfilling whatever your goals and objectives are. And here's where this goes back to the point I was making earlier about the most common planning mistake that I see. All of these assets up here in this taxable bucket, the IRAs, the 401ks, the 403bs, the TIAA CREF accounts, they are controlled by beneficiary designation, which means they avoid probate, which also means they are not controlled by your last will and testament. So in order to shift some of the taxable assets to the tax-exempt people and reduce your tax liability while also fulfilling some charitable intent, all you have to do in most circumstances is change a beneficiary designation. You don't have to change your will. You don't have to go to an attorney. You don't have to pay a fee. And if you change your mind, you can then turn right back around and change those beneficiaries right back to whatever you want them to be. That's the best way of doing it. And let me give you a quick example of what that might look like, a real-life example. This is a couple I worked with many years ago. When I first started with Thompson Associates, at the time we had a contract with the Baptist Foundation of Alabama. Now, as one of the junior members of the firm at that time, what that meant for me was every month I got to spend a week in a little bitty town in Alabama working with the local Baptist church and the members there to help them with their estate plan. And it looked a lot like what we're doing here. I would do a seminar typically on a Saturday, and people would attend, and anyone that attended had the opportunity to meet with me the following week in a confidential environment to talk one-on-one about their specific situation so they could get the information they needed so that when they walked into their local attorney's office to get their stuff done, they knew exactly what they wanted to do. So hopefully that process was less expensive and maybe at least less scary, right? And they ended up with plans that were theirs, that they had put some thought into. And one of the couples that I worked with on one of those trips to one little town in Alabama was this couple right here. And they were in their mid to late 70s when they came to see me. They had one son who was in his mid-40s who had a couple kids of his own. So in their minds, he had done his job and given them grandkids. And he lived nearby, so it was great, right? And I'll never forget, they walked in, and the gentleman walked in first, and he was kind of hunched over a little bit, and he had this manila envelope he was holding on to, and he wouldn't look at me, certainly wouldn't look me in the eye, and his wife walked in behind him with a little clutch purse in her hands, and she was kind of hunched over and wouldn't look me in the eye. Now, that's not all that uncommon as an attorney. People are often scared to look me in the eye. But they came and sat down across from me at the little table in the little room at the church, and they said, well, Jeremy, we're kind of embarrassed to be here. We're probably wasting your time. We just had our wills and powers of attorney and healthcare documents and everything else done a few weeks ago with an attorney here in town, and the truth is we really don't have anything to speak of, and so, you know, probably wasting your time, but, well, you're free, so we thought we'd come on in and at least have you look at these documents to make sure they're okay. And I said, okay, great. Let's take a look at those. So I opened up that manila envelope, and I pulled out those documents, and I read his will, and it was a simple, I love you will, right? Everything to his wife and then to his son. And his wife's will said the same thing in reverse, and his powers of attorney looked fine, and his healthcare documents looked good, and his living will was fine, and I told him so. And I said, no, this all looks great, you know, probably all you need. He said, well, that's kind of what I thought, and, you know, I'm sorry to waste your time, but I appreciate you giving me a second opinion there. And I said, well, no, hold on a second. We've still got 55 minutes left in our hour. So, do you mind telling me a little bit about what you have? And he said, well, sure, that's not a problem. I said, do you own a home? He said, yeah, I own a home. I said, do you owe anything on your home? He said, no, we don't do debt. I said, great, good for you, I do. He said, how much is your home worth? And he said, well, I don't know, but the house across the street that's just like mine, in fact, it's not as nice as mine. It just sold for $200,000, so that's probably about right. So I wrote that number down. I said, well, do you have any savings? And he started listing some things off and some mutual funds he threw some money into way back when. And we started adding all that up, and it came up to about $150,000 of cash and other investments. I said, do you have a life insurance policy? He said, yeah, I've got this whole life policy with $100,000. Mainly it's so the missus can bury me and then go have a good time after I'm gone. She's been waiting a whole life for that. So that'll be good for her. And I said, well, do you have a retirement account? He said, yeah, I got this little IRA account. I threw some money in way back when I was working. And so it's got about $50,000 into it. He said, I hate that thing. I'm taking those distributions they make me take and paying the taxes on it. And I don't need that money to live. And I really don't like paying the government more than I have to. I said, I understand. I said, well, hold on a second. Let me do some quick math. And so I did some quick math, which I'm not real good at. And I said, well, you're worth $500,000. And I'll never forget, his wife had not moved to this point, had not even looked up. She slaps the table as hard as she can and says, no, I am not. And I said, well, I'm sorry, ma'am. Math is not my strong suit. Let me try that again, right? We went through that exercise 4 more times before I could finally convince that woman that she was worth $500,000. She looked me square in the eye for the first time and said, now you keep telling me I'm worth all this money. Why am I still clipping coupons? I said, ma'am, that's why you're worth $500,000, right? I said, but the truth is, you don't feel like you're worth $500,000. You're never going to feel like you're worth $500,000 because you're never going to see most of this $500,000, right? You've lived in your house for 40 some odd years. You don't plan on ever leaving. You plan on dying in that house. You're not going to see that money. These investments are there kind of for a rainy day. You don't ever touch that money. You don't plan on touching that money unless you absolutely have to. And if you do, it won't be because you feel wealthy. It'll be because you're in trouble. You're not touching this money in the IRA because you don't like paying the taxes on it, and you don't need it either. And at least one of you, if not both of you, is not going to see this $100,000 from the life insurance policy. But here's kind of the trick to all this. When you're both gone, all this turns into a big wad of cash for your son. He's going to see all of this money, right? And I said, but not necessarily all of it, because he's going to have to pay some taxes. And just to make my math nice and easy, let's assume a 30% tax rate. That's about $15,000 of taxes he would have to pay on this IRA account, and he'll end up with $485,000 at the end of it. And that's when the gentleman slaps the table real hard. He's a really good table slapping people from Alabama. And he said, now hold on, I've paid Uncle Sam all that he's due. I don't want him getting any more from me after I'm gone. What can I do about that? I said, well, the only thing you can do to cut Uncle Sam completely out of your estate is to take the asset that's creating that tax liability, that IRA account, and give it entirely to something tax exempt, a charity, a church, something like that. He said, what would that look like? I said, it would look like this, right? You'd give that IRA account when you die, and more specifically, after you and your wife are both gone, you'd give them that account away to charity. The rest, $450,000, would go to your son. So I do want to be clear now. Your son's not getting $485,000 anymore. He's only getting $450,000. But Uncle Sam is not getting anything. And he looked at me and kind of chuckled and said, well, that's a whole lot more than my son's expecting. He'll get what he gets and not throw a fit. I said, yes, sir. By this point, I was more scared of him than he was of me, I can tell you that much. Right? But he kind of smiled with a sideways grin. He said, but hold on. He said, this sounds a little bit too good to be true. You attorneys are always a little sneaky. How much is this going to cost me? I said, well, nothing. He said, well, what do you mean? I said, well, that IRA account that's creating that tax liability is controlled at your death by beneficiary designation. It's not controlled by your will. It doesn't go through probate. So if you want to change where that goes from your son to your favorite charity or charities, it could be multiple charities by percentages, however you wanted to do it, all you've got to do is go in and change the beneficiary designation from your son to those charities. You can do that for free, and oh, by the way, if you change your mind, you can go back and change it for free whenever you want to. He said, well, shoot, John handles that for me down at my Edward Jones. I'll go take care of that this afternoon. At that point, I looked back to his wife and I said, ma'am, do you have any questions? Does this sound right to you? And when I did, I noticed she was a little misty-eyed. I said, ma'am, I have that effect on women all the time. Is everything okay? She said, well, hold on a second. She said, you're telling me I can leave $50,000 to my church? I said, yes, ma'am. She said, I've never written a check for more than $50 to my church. Could we start a mission fund? I said, I have no idea. Let's go find out, right? So we walked down to the church leader's office. I opened the door, said, this couple would like to talk to you about something, and then I went back down to my next meeting. I don't know how their meeting went, but the next morning when I came to my first meeting, there was a nice handwritten note from that lady and a homemade coconut cake. So it went pretty well, I guess. That's the one thing Vanderbilt didn't tell me. I was going to get paid in coconut cake. They don't accept that, by the way, for tuition payments. That's what a thoughtful estate plan can look like, very simply. It costs nothing except 45 minutes of time with somebody who knows what they're doing, putting a little thought into what they could do with what will be far and away the largest financial transaction that this couple will ever control at any stage of their life. And for that little church in that little town in Alabama, whenever the time comes, that'll be a church-altering gift. And I met with 20 other people from that church just like this couple. And you think about the difference that this could make, right? Think about how much you might look like this couple, or a multiple of this couple, or how many people here at Great Oaks look something like that, right? That's what good estate planning can accomplish. It requires thought. It requires knowledge. It requires time. But most of all, it requires you wanting to do what you can do in a way that meets your values with what will be everything you've been blessed with throughout your life. And so what we've also provided is an opportunity for you to talk about you. We've got a couple days scheduled, one in January, one in early February, where I'll be back here on the church's campus, available to meet with anyone that wants to, one-on-one. And I say one-on-one, you can bring anyone to the meeting that you want, but the meetings are completely confidential. No one at the church or at Freed Hardeman learns anything that we discuss. But I do want to be clear about a couple of things. I will never charge you a fee. My fee's already been paid. Our company's fee's already been paid. We're held on retainer by Freed Hardeman so that they can offer this service to people free of charge. We don't sell anything. We don't manage investments, so I didn't invite you to the free estate planning seminar to convince you I'm an expert and then ask you to move your money over to me to manage later. I'm not going to sell you that 6-inch thick trust book at the end of the whole thing or anything along those lines, right? I'm not here to act as your attorney. I won't actually draft the documents for you. I won't draft the wills or the trust or whatever it is you need. I am an opportunity for you to learn what you need to do, why it's important for you to do it, and the steps you need to take to make sure it gets done so that when you walk into your local attorney's office here or your local advisor's office, you know you can drive that discussion, right? You're not the deer in the headlights walking in, right? That's what this service offers, right? And so we'll talk about what you want to do, we'll talk about what you have to do it with, and we'll talk about what recommendations you have. Now, when I say I'll assist with implementation, what that means is if you need me to help you find an attorney, I've worked in the Memphis area for a decade now. I know a lot of the top estate planning attorneys. If you need help finding one, I can help you find one, point you in the right direction. If you want me to have discussions with that attorney to make sure nothing's lost in translation, or you've got more questions after you go talk to the attorney and want to run them by me too because I'm free, and you want a second opinion, happy to do that too. Even if you want me to review drafts of documents with you that the attorney prepares before you actually sign them, I can assist with that too. I can do anything but actually be your attorney of record. All right? And so, happy to do all of that as well. All right? So this is that opportunity. And if you want to take advantage of that, all you got to do is come up here. We got sign-up sheets for both the days that I mentioned. You can sign up for a time slot. Grab one of the values-based questionnaires, which is this pile labeled for all, and then grab the appropriate net worth worksheet. There's one for married couples and one for single individuals, right? Grab one of those. Fill them out as best you can, but don't worry about it if you don't answer some questions at all. Bring that to the meeting whenever your meeting time is scheduled, and we'll go over all that information and start talking about what you need to do. Okay? And so that gets us started. All right? It's really about making sure you've got the information you need to create an estate plan that matches your values and objectives, just like mine, right? You can have my boys, but as long as my little girl's taken care of, we're all good. Okay? So thank you for your time this afternoon. I'm going to stop there, let y'all sign up if you want to. But before we do that, are there any questions, any specific questions for me before we dismiss? Yes?
Give me a range of what it's going to cost to talk to an attorney.
Yep.
Is it about an hour? Is it about a document? Is it about a...
The good attorney answer is it depends. No, I'll give you a range. Some bill by the hour, some bill by the plan. And so I would tell you, interview a couple of attorneys and ask those questions. And pick the approach that you are most comfortable with. Part of the goal with this process is if you end up with an attorney that bills by the hour, there will be less time needed discovering information or talking about what you want to do. And so therefore, hopefully, this will be a little bit easier and less expensive process when you actually go do it. That, from a financial standpoint, that would be the benefit of doing this. But, you know, I typically tell people getting a will done, as a general rule, anywhere from $500 to $1,500 as a range. You might find an attorney, if you're getting simple plans done, that will charge less, $250, $300. You're certainly going to find an attorney, if you want to, that will charge more. Don't go to the top floor of one of the big buildings downtown, right? Because then you're just paying for the overhead. But a lot of it is dependent upon what your plan is. Simple wills, everything for a spouse, maybe trust for minor kids, or not if the kids are adults, or whatever it is you're wanting to do. A few $100s is probably what you're looking for. And in that circumstance, you don't need to go to the boutique estate planning firm to get that done. You can go to the general practitioner that does wills as part of his practice, as long as he does wills as part of his practice. If you get into more sophisticated trusts, revocable trusts to avoid probate and things like that, then you're gonna spend a couple grand or more. Yes.
When you talk about shifting those taxable assets
Mm-hmm.
to charities,
Yes.
can that be any 501(c), or are there parameters around the types of charities you can donate or shift those taxable assets?
That's a great question. And again, the short answer is it depends. The longer answer is at death, it's pretty much any tax-exempt organization. At death, if you're making direct gifts, you can give to a church, a charity, a private foundation, a donor-advised fund, a variety of different organizations, as long as they are a tax-exempt organization under the law that allows for charitable deductions, you will avoid the taxes. A little bit different during life with some of these assets and gifts, but at death, that's pretty much it. Yes?
That was kind of my question too about the revocable trust.
Mm-hmm.
Anybody that does something like that, you're looking at a couple grand maybe.
Yeah, probably maybe a little bit more depending
What
on.
about your financial advisor? We work with a financial
Mm-hmm.
advisor in town, and they can do all
They can do
that.
that?
Well,
But I mean, that's a good
because they already know kind of
what you've got. Yeah, and so you may get a discounted rate there depending on what their agreements are with if either in-house attorneys or attorneys they consult with. The question was about a revocable living trust. Let me take just a minute because you may have heard of revocable living trust, or you may have said, well, mom had a trust, or my friend had a trust, or whatever it might be. Revocable living trusts are the most common forms of trust that may not be exactly right, but they're one of the most common forms of trust used for estate planning. And basically, what a revocable living trust is a substitute for your will in that it becomes the document that outlines where you want all your stuff to go when you die. The difference is the method by which it happens. A will, as I've mentioned, requires the probate process. It's an instruction manual for the probate process and only controls the assets that go through probate. A revocable living trust is designed to do all of the same things, but do it outside of the probate process, to avoid probate, to allow everything to happen privately. It's important to understand how that works if you're going to try and use one. Because I often refer to revocable living trust as prepaid probate, right? It costs more money to get a trust drafted that does the same thing as your will. So you're paying more of the cost. It's not going to be as much as the probate process, but it's going to be somewhere in between. A couple grand, a few grand, something along those lines typically. Maybe more depending on how sophisticated it gets. But you get this trust done now. And initially you're the trustees, typically, and you're the beneficiaries. So you still control everything in the trust, you still use it however you want, and you can revoke it, get rid of it, or amend it at any time, just like a will, as long as you're alive. And for all of those reasons, it is a see-through entity, a pass-through entity for tax and liability purposes. It doesn't get a separate tax ID number, everything flows through to your 1040, it's still treated like yours, nothing really changes while you're alive. But if you have retitled all of your assets that would otherwise go through probate into this trust before you die, then technically you don't own anything when you die. So nothing has to go through probate. The trust already owns it. The trust is a contract, private document. It can then distribute the assets however the trust says to distribute them, just like the will would, but without having to go through the court-supervised probate process. And that can be a real benefit in certain circumstances. I mentioned ancillary probate. If you own real estate in more than one state and your heirs are going to have to go through probate in multiple states with multiple courts and multiple attorneys, avoiding probate may be a higher priority. Revocable living trust can be a good option. I've mentioned a couple times that a will only has power when it's admitted to probate. Well, guess when it's admitted to probate? When you die. So guess who isn't there to help make sure that it's admitted to probate? You. Right? Somebody else has to go find that thing. And typically only originals can be admitted to probate. So if the original was lost, destroyed, or whatever, then that can become a bit of a problem. Revocable living trust, you have to avoid that. That's really, really important often in blended family situations, right? Because under the laws of the state, when someone dies, only their biological or adopted children are entitled to inherit, absent a will that says otherwise. So you can imagine in this wonderful Brady Bunch blended family, right? And dad dies, and then 10 years later mom dies, and mom's daughter Susie, who has been helping with all the financial affairs the last couple of years of mom's life, finds the will that mom and stepdad did 15 years ago that says everything's divided equally amongst all 6 of the wonderful Brady Bunch. Well, Marcia doesn't really care for that a whole lot because maybe she hadn't talked to her stepbrothers in a few years, and so that wonderful will accidentally falls into a shredder on the way to the probate court, right? And then the only people entitled to inherit are the girls, right? Revocable living trust already owns everything, right? So there's no way for that kind of thing to happen, and so that, there's some protection there. There's a variety of other reasons, but for that added cost, you've got to do what you got to do. The biggest problem with them tends to be the fact that people don't live their lives based on their estate plan, which is a shocker, I know. And so even with perfectly well-drafted revocable trusts, there often still has to be a probate process. Because if you sell your house and buy a new home, you don't typically walk into the closing and say, oh yeah, don't put that house in my name. No, it's got to go in my trust. I forgot I did this estate planning 10 years ago. Don't do that. Right? And you end up with a house in your name. Or you change banks, or you buy something else, or whatever it might be. And if you forget to put something in the trust, it's still going to have to go through probate when you die.
Sir?
Yes?
Two-part question.
Yep.
First part, what is your opinion of a do-it-yourself power of attorney you can print off the internet?
Mm-hmm.
And if I use that, can my wife and I both be named as the grantor to the person we are giving the power of attorney to, or only one of us?
Okay. This is a good question. I'm a little bit, the bottom line is I'm leery of do-it-yourself kits. The language is often fine. The decisions they ask you to make is where the problems exist, or the questions they ask, because most of the time people don't understand why the questions are being asked or the importance of answering them in certain ways. And so, in my experience, whenever these do-it-yourself documents are brought in for me to review, they are worth less than the paper they're printed on. The other reason for that is because people don't understand what makes a document legal, right? Necessarily in a lot of circumstances. For example, in Tennessee, for a will, it has to be signed by you, right? Your signature. If it's a typed or printed will, it has to be witnessed by 2 disinterested witnesses. That's what makes it legal, not the notary. The notarized part of it is a part that's referred to as the self-proving affidavit. That just means that when you die, the will's already been proven by having it notarized and having that affidavit attached to the will, so that you don't have to go find those 2 witnesses and bring them in to testify in the court that you did sign this will after you're dead. And so people will bring these documents in, they'll be notarized, but they won't be witnessed. Or they'll be witnessed and they won't be notarized, which means when they die, it's a perfectly valid will, but the only way to validate it in front of a probate court is to go find those 2 people, and who knows where they are. Right? And so there's little things like that in addition to the language. But with that said, if it's a simple power of attorney, where you're simply naming somebody to act as your agent in the event you cannot, if you've signed it, witnessed it, notarized it properly, is probably going to be just fine. But you should each do your individual powers of attorney. These are good questions. Any other questions? Real quick. Everybody sick of death and taxes for the day? Or just sick of the attorney? What? Yes?
Where does an annuity fall in?
It's a good question. And again, it depends. But because, and here's why. The question is, where does an annuity fall into this stuff? Okay, the problem with that question is that very, very often annuities are part of the investment portfolio in an IRA account, which is different than just purchasing an annuity directly from like an insurance company or something like that. From a tax perspective, it's different. If it's bought within an IRA account, it's bought with pre-tax money, and so the entire thing is taxable. The entire value of the annuity, the original principal or the original basis, and all of the deferred interest, it's all taxed as ordinary income. It can be a great investment in like an IRA or 401k because all of that interest is tax deferred. So they can pull that interest out and reinvest it and do whatever, right, all in a tax exempt environment. If you're just purchasing an annuity from a life insurance company, which often happens towards retirement, and you're moving towards fixed income, right? Then the basis, the after-tax money is always tax-free. All of the deferred interest is taxed as ordinary income. So if you die with an annuity that you purchased directly with after-tax money, then it's actually partially tax-free and partially taxed as income. All of the interest that's been deferred that you haven't pulled out yet is taxed as ordinary income, but the basis, what you bought the annuity for, is tax-free. The best example is it's like a stock, right? You buy a stock, you got basis in the stock, you hold on the stock for 10 years, it doubles in value. When you sell it, you only pay taxes on the increase, not on the basis that you bought it for. An annuity is similar, except all that deferred interest is taxed as ordinary income.
It was originally a rollover.
Mm-hmm. If it's a rollover, then it's almost certainly in some type of tax-deferred account, which means it's
just an annuity. It's a rollover instead of going into another 401k or an IRA.
Yep.
So how does that work? Because you said a 401k, you can't leave to charitable.
No, 401k you can. You can leave any of these accounts directly to charity at your death, and that's a good point. I maybe should clarify that. At death, the rules are different with all of these accounts. 401ks, 403bs, IRA accounts, tax-deferred annuities. You can leave all of those by beneficiary designation directly to a charity at your death, and none of the taxes will get paid. The difference is that qualified charitable distribution if you're trying to use it to make gifts while you're alive. You can only make gifts using that qualified charitable distribution law while you're alive from an IRA, and it qualify, not from a 401k or a rollover annuity or anything along those lines. Did that make sense?
When you're dead, and you
When you're dead, doesn't matter. Name the charity as a beneficiary, it saves all the taxes.
doesn't matter now.
Yeah, that's right. That's right. Good question. Any other questions? Yes, ma'am.
This is a what if. You leave your money, you have a will, and you leave it to 3 grandchildren. The 4th grandchild, for whatever reason, you did not leave that grandchild anything.
Mm-hmm.
That grandchild contests that will.
Mm-hmm.
What are the chances that he can do that, and when?
Well, the chances that he can do that are 100%. The chances that he'll win are probably very, very small if the will was done properly. Almost zero. Because what he's got to prove is either that you were incompetent when you did the will, or that somebody influenced you unduly to leave him out. And that's going to be really hard to prove. Now, the other part of it is, and I may not have heard the entire scenario directly because I was thinking as you were talking, but he's not challenging the will. What challenging the will does is voids the will. It just gets it tossed, right? So if it's a grandchild, doing that wouldn't necessarily do him a lot of good, because if his parent, the child, was still alive, the grandchild wouldn't be entitled to inherit anything anyway at that point. He's still got to wait till dad dies or mom dies, whatever the parent is.
Is it true if you're doing that and you want to specifically leave someone off, but you don't want them to challenge it? If you leave them $1, that proves?
No, it doesn't make a difference. In fact, that actually causes problems in a lot of circumstances. Not the least of which it'll tick them off and maybe motivate them to challenge, right? But what it also does is if somebody's named in the will, and this is the other reason why using beneficiary designations becomes a great way of redirecting assets. If something's named in a will, they become part of the probate process with everybody else that's either named in the will or might be entitled to inherit under the law from the estate. Because they all have to be notified, which means they've got to get copies of the will. They've got to be notified of everything that's going on so they can challenge if they choose to. And they are aware of that fact. Not having them named in the will, if they're not entitled under the law to inherit anyway, means they likely don't have to be informed of everything that's going on. And beneficiary designations that avoid probate, there's no informing there at all. And so that can be a good approach. Well, thank you for your time. I've actually got to get back on the road to Nashville because those 4 kids are sitting at home without adult supervision at the moment. So there goes more of my money in home renovations. The sign-up sheets, as I mentioned, for the 2 dates, if you want to meet personally, are right up here. Along with the questionnaires I mentioned, grab one of the values-based ones in whichever net worth worksheet applies to you, and grab a copy of William's book if you want that as well. Thank you for your time. I'm sorry I have to get out of here so quickly.
Thank you.
You're welcome. Thanks, Rena.